Hi and very good day to Dr. Schneider. We are from TJ6 Group Cadbury, and this is our video presentation for Group Assignment 1. And these are the members of Group Cadbury. First, we have Nur Atika binti Muhammad Qasim, BB1911038, and then Nur Adiba Zulaika binti Arapa, BB191100452, and then we have Iza Nazira binti Tukiman, BB20110621, and me, Nur Shafini binti Muhammad Shan, alias Abdul Shan, BB1911067. So we are choosing partnership for this group assignment. And first of all, I would like to start with nature of business partnership. Partnership Article 1961 is specifically the law of the partnership that have been governed in Malaysia. And then I would like to move to the definition. Definition in partnership have stated in Section 3, Subsection 1 of the Partnership Article 1961 that that stated partnership is a union that can be described as the relationship that exists between people who do business together for the sake of profit. And then this group will be run a business. According to Section 2 of the Partnership Article 1961, the term of business are including every trade, occupation, or profession. And then I would like to move to the main characteristic of partnership. Partnership is also called as a firm, as it's stated at Section 6 of the Partnership Article 1961. And then, a partnership has no legitimate personality aside from the identities of participants. When a firm is sued, a third party can sue the partner by filing a lawsuit against the partnership in the firm's name or in the names of any of the individual partners as defendants. And then there are two types of partner in partnership, which is first is active partner that show active action with the firm's business management. And then in partnership, we have sleeping partner, which is that not show any involved with the management of firm. Then there are several advantages in partnership, which is easy to create and has a low startup cost, and then allows a group of individuals to combine their resources and scale. And then the last one, it has limited regulation by authorities and the partners tax individually. And then the disadvantages, including unlimited liability. Then the partner individually are mutually accountable for all the firm's debt. And then the last one, partners can legally tie each other without seeking prior consent. And then next, I would like to move the legal procedure involved. For your information, the registration is different between Peninsula, Sabah, and Sarawak. For Peninsula, partnership required to register based on the Registration of Business Article 1965. And then for Sabah, it is under the Trade Licensing Ordinance number 69, 1948. And then the Sarawak, it is under the Sarawak Cap 64 Business Names and Cap 33 Business Profession and Trade Licensing. And then in the Section 3, Subsection 1 of the Partnership Article 1961 have stated the minimum partners to create the partnership, and then the minimum partners required is 2 partners, and then the maximum is stated in Section 47, Subsection 2 of the Partnership Article 1961. The maximum partners are 20 participants. And then the partnership agreement does not have to be established into a formal deed or written arrangement, while it can be produced orally or in writing document, as it is stated in Section 3, Subsection 2 of the Partnership Article 1961.
Assalamualaikum. My name is Nur Adiba Zulaika binti Arapa. My matrix number BB191100452. So, I want to present a draft agreement. The background of the business is partnership name and purpose. The partners agree to form partnership under the name of Burhan, Oscar, and Mimi Partnership. The partnership will be governed in accordance with the laws of the state of Malaysia. The partnership has been formed on the terms and conditions set forth below to engage in the business of supplying stationeries and textbooks for UMS students. Place of business, the principal office of the partnership will be located at University Malaysia Sabah. Partnership term, the partnership shall commence on the effective date and will continue until it terminates in accordance with the terms of this agreement, unless terminated early in accordance with the term of this agreement. According to the Business Act 1956, Section 5, the details of the partners and their agreement must be given. If there is any changes made subsequently, the registrar must be notified within 30 days. And then capital contribution. Borhan will provide cash 50,000. Oscar will provide cash 50,000, and also Mimi will provide cash 50,000 ringgit. Then partners capital amount and withdrawal. Borhan, Oscar, and Mimi partnership will establish and maintain for each partner a separate capital account consisting of the partner's capital contributions. Partner may not withdraw any portion of capital from his or her capital account without the written consent of all partners. Interest at the rates and times as determined by the partners will be paid on the capital account of any partners. After that, distribution of profit and losses. The partnership's net gain will be split evenly by the partners, who are Borhan, Oscar, and Mimi, and the partnership's net losses will be shared equally among them. Each is supposed to keep a separate income account based on Section 26A of Partnership Act 1961. Partnership gains and liabilities must be paid or attributed to each partner's independent income account. If a partner has no credit balance in his income account, they match and credited to the partner's capital account. This provision often refers to transactions made after a relationship has been ended due to the death of a partner, but before the partnership affairs has been properly wound up, either by any living partner or by the deceased partner's representatives in Section 31(2) of Partnership Act 1961. Lastly is partnership books, fiscal year, and audits. According to Section 26(1) Roman of Partnership in Act 1961, the partnership books shall be held at the Partnership Principal Office in Kota Kinabalu, Sabah, and Borhan, Oscar, and Mimi shall have constant access to them. The account must be held on a fiscal year schedule beginning in January 2021 and closing in December 2021, and they must be closed and balanced at the end of each fiscal year. An evaluation must be performed as of the closing date. This partnership is the growth of a small company founded on friendship and confidence. Record can be incomplete, but they will be kept in accordance with existing industry practices. Audits will be inefficient and costly, but instead of depending on independent auditors, the partners would depend on themselves to equally allocate costs and income. That's all. Thank you.
Assalamualaikum and hi, I am Izana Zira binti Tukiman, BB2010621, and I will continue the presentation from the previous slide. Management and duties. According to Section 10, the firm will not be bound in respect of any act done in contravention of the agreement if the third party has notice of the agreement between the partners that there are some restrictions on the power of any one or more of them to bind the firm. Next, according to Section 11, while he is a partner and after his death, his estate is also severally liable in a due course of administration for such debts and obligations. Every partner in a firm is liable jointly with other partners of the firm incurred, so far as the subject of the prior payment of his separate debts remain unsatisfied. Next, according to Section 21, the mutual rights and duties of partner may be varied by the consent of all partners, and such consent may be either expressed or inferred from a course of dealing, whether ascertained by agreement or defined by this Act. Next, according to Section 26, between the partners, the interests of the partners in the partnership property and their rights and duties in relation to the partnership shall be decided subject to any agreement expressed or implied by the following rules. E. Every partner may take part in the management of the partnership business. F. No partner shall be entitled to recompensation for acting in the partnership business. H. Any difference arising as to ordinary matters connected with the partnership business may be decided by a majority of the partners, but no change shall be made in the nature of the partnership business without the consent of all existing partners. Next, miscellaneous provision. According to Section 12, loss or injury is caused to any person not being a partner in the firm, or any penalty is incurred. The firm is liable, therefore, to the same extent as the partner so acting or omitting to act, by any unjust act or omission of any partner acting in the ordinary course of the business of the firm, or with the authority of his co-partners. Next, according to Section 13, in the following cases, namely A, where one partner acting within the scope of his apparent authority receives the money or property of a third person and misapplies it, and B, where a firm in the course of its business receives the money or property of a third person and the money or property so received is misapplied by one or more of the partners while it is in the custody of the firm is liable to make good the loss. That, according to Section 15, if a partner being a trustee improperly employs trust property in the business or on the account of the partnership, no other partner is liable for the trust property to the persons beneficially interested therein, provided as follows. This section shall not affect any liability incurred by any partner by reason of this having notice of a breach of trust. And B, nothing in this section shall prevent trust money from being followed and recovered from the firm, if still in its possession or under its control, person liable by holding out. Then, according to Section 31, every partner must account to the firm for any benefit derived by him, without the consent of the other partners, from any transaction concerning the partners, or from any use by him of the partnership property, name or business connection. This section applies also to transactions undertaken after a partnership has been dissolved by the death of a partner and before the affairs thereof have been completely wound up, either by surviving partner or by the representatives of the deceased partner. According to Section 32, if a partner without the consent of other partners carries on any business of the same nature and competing with that of the firm, he must account for and pay over to the firm all profits made by him in that business. Next, partnership property. According to Section 22, all property and rights and interests in property originally brought into the partnership stock or acquired, whether by purchase or otherwise, on account of the firm or for the purposes and in the course of the partnership business, are called in this Act partnership property, and must be held and applied by the partners exclusively for the purpose of the partnership and in accordance with the partnership agreement, provided the legal estate or interest in any land which belongs to the partnership shall devolve according to the nature and tenure thereof and the general rules of law applicable thereto, but in trust, so far as necessary for the persons beneficially interested in the land under this section. Next, according to Section 22(2), where co-owners of an estate or interest in any land not being itself partnership property are partners as to profits made by use of the land, and purchase other land out of the profits to be used in like manners, the land so purchased belongs to them, in the absence of any agreement to the contrary, not as partners, but as co-owners for the same respective estates and interests as are held by them in the first land first mentioned at that of the purchase. Then, according to Section 23, unless the contrary intention appears, property bought with money belongs to the firm, is deemed to have been bought on account of the firm. According to Section 24, it shall, unless the contrary intention appears, be treated as between the partners, including the representatives of deceased partner, where land or any interest therein has become partnership property, and also as between the heirs of a deceased partner and his executors or administrations as personal and not real estate. Then, according to Section 26, the interests of partners in the partnership property and their rights and duties in relation to the partnership shall be determined subject to any agreement, expressed or implied between the partners by the following rules. A. All partners are entitled to share equally in the capital and profits of the business, and must contribute equally towards the losses, whether of capital or otherwise sustained by the firm. B. The firm must indemnify every partner in respect of payments made and personal liabilities incurred by him, first in the ordinary and proper conduct of the business of the firm, or two, in or about anything necessarily done for the preservation of the business or property of the firm. Lastly, according to Section 9, where one partner pledges the credit of the firm for a purpose apparently not connected with the firm's ordinary course of business, the firm is not bound unless he is in fact specially authorized by other partners, but this section does not affect any personal liability incurred by an individual partner. Then, admitting a new partner. According to Section 19(1), a person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner. According to Section 26, the interests of partners in the partnership property and their rights and duties in relation to the partnership shall be determined subject to any agreement expressed or implied between the partners by the following rules. No person may be introduced as a partner within the consent of all existing partners. Lastly, voluntary withdrawal or retirement partnership. According to Section 19(2), a partner who retires from a firm does not thereby cease to be liable for partnership debts or obligations incurred before his retirement. According to Section 19(3), a retiring partner may be discharged from any existing liabilities by an agreement to that effect between himself and the members of the firm as newly constituted and the creditors. And this agreement may be either expressed or inferred as a fact from the course of dealing between the creditors and the firm as a newly constituted. According to Section 27, no majority of the partners can expel any partner unless a power to do so has been conferred by express agreement between the partners. According to Section 28(1), where no fixed term has been agreed upon the duration of the partnership, any partner may determine the partnership of any time on giving notice of his intention to do so to all other partners. Lastly, according to 28(2), where the partnership has originally been constituted by a written document, a notice in writing signed by the partner giving it shall be sufficient for this purpose. That's all for my presentation. Thank you.
Hello, I will continue the draft agreement. My name is Nuratika binti Muhammad Kasim and my matrix number is BB19110-38. Solution of partnership. First, dissolution by notice. In accordance with Section 34 of the Partnership Act of 1961. Second, dissolution by bankruptcy, debt and charge. In accordance with Section 34, when one of the partner dead, the partnership is terminated unless there are proof that the partner decide otherwise. The partner decide to the contrary will have been made prior to the date and the partner. Agreement made between the remained partner after the death of the partner without the agreement of the decreased partner does not tie the decreased partner and does not convert the relationship in the continuous partnership. Third, dissolution by illegal. Third, third, dissolution by illegality of partnership. In accordance with 36. Third, dissolution by illegality. Third, dissolution by illegality of partnership. In accordance with Section 36 of the Partnership Act of 1961, the partnership is dissolved in any case upon the occurrence of some incident that make it invalid for the firm business to be carried on or for the member of the corporation to carry on it in partnership. And lastly, dissolution by the court. In accordance with Section 37 of the Partnership Act 1961, allow the court to terminate an agreement on the request of one of the parties. There are several reasons of court can order the parties to dissolve. First, the partner confirm lunatic and not to his or her state for mind. Second, the partner cannot perform his or her responsibility for the firm. Next, the partner found guilty doing something that can affect the partnership, breach the partnership agreement that can affect the firm and others member. The partnership suffer prolonged loss. And lastly, any action or case the court believe in equitable act in order to maintain the names and performance of the partnership firm. All the member is forbidden for doing actions as follow. First, in accordance with Section 32, the partner is not allowed to establish the company that have a same nature with the firm. Therefore, if the partner found guilty, they can be fined by paying the amount of profit he or she got from the new established firm. Second, the partner is not allowed to involve in any illegal activity such as gambling, drugs, and others criminal action that can affect the firm names and cause the partner to dissolve. In accordance arbitration, each conflict resulting from and relevant to this agreement that the partners are unable to resolve by themselves shall be resolved in compliance with the Arbitration Act 2005. The arbitrator right ruling if applicable, shall be definitive and binding on the partner. Any court with jurisdiction over the matter may enter judgment on a mandatory award and enact injunctive or specific performance relief provided by the arbitrator. Entry agreement. This agreement contains the partners' entry understanding and supersede and cancel any previous agreement, whether oral or written, between the partners with respect to such subject matter. And lastly, amendment of agreement. This agreement may be amended or modified only by the written agreement signed by all of the partners. Thank you.